Good morning, everyone.
Good morning,
I
Diana.
want to welcome everyone to today's Fexa and Friends Network show. Thank you for joining us and sharing a few minutes of your day with us today. We're going to give everyone another 30 seconds, 45 seconds to join us. I still see people logging into the show. So we're going to wait just a few more seconds as people come on in and join us. I hope everyone is having a good morning and or afternoon on the East Coast. Okay, got a couple of more folks coming in, and I think we should get started. Welcome to today's show. We hope you are able to take away something from this and every Fexa Network show that you are able to use or at least expand your knowledge base in your professional life. I'm Diana Hart, the host of the Fexa and Friends Network. The purpose of the Fexa Network is to be a place to offer education, best practices, and trend opinions to the multi-site facilities and service provider communities. If you have a topic that you would like to see on a future Fexa Network show, or if you would like to be an educator yourself, please drop me a line at fexafriendsnetwork@fexa.io. We hope you continue to support this growing effort to educate and uplevel the facilities management community by showing up and engaging with our topics. A quick note about Fexa, this program's primary sponsor. For those of you who don't know Fexa, we create smart, flexible, and easy-to-use facility management software for multi-site companies. Fexa transforms business processes into automations and workflows that find efficiencies to save time and resources. Fexa's data-driven asset management programs help companies track, analyze, and optimize repair or replace decisions. We also help companies track the refrigerant emissions for regulatory compliance and ESG reporting purposes. For more information about Fexa or to request a demo, hop on over to fexa.io. I also want to let everyone to know that even though your mic is muted, this show is interactive. And if you have a question for my guest educators today, please type your question into the chat window at any time during our conversation. We will get to as many questions as we have time for. If you have ever wanted to ask an insurance risk management consultant a question, today is your lucky day. So don't hold back, because if it's on your mind, others are probably thinking about it too. And now we're going to turn over to today's topic, mitigating risk when hiring and managing service providers and contractors. This is an issue that is intensely interesting to our entire audience today, which really is a mix of retail, grocery, and restaurant operators and many service providers. Obviously, all parties want to be protected in any working relationship while also having the flexibility and freedom to get the job done correctly, on time, and on budget. And with that in mind, I want to welcome my first guest expert, Blake Lezak from Safety Facility Services. Blake has an extensive background in facility maintenance and management, managing self-performed and subcontracted services throughout the US, Puerto Rico, and Canada. He also worked for a national insurance brokerage with a concentration on general liability and workers' compensation insurance. Welcome to the show, Blake.
Thank you so much, Diana. Really appreciate you having us. Before I kind of jump into a quick introduction, just wanted to again thank you and the entire Fexa team, Mark Balsamo, Kim Gui, everybody there at the company for, thinking of us and keeping us top of mind when you were putting the show together. As far as safety facility services, we are a New York-based facility maintenance company. We specialize in janitorial, repair and maintenance services, snow removal, security services, and a wide variety of interior and exterior property maintenance services here in the tri-state, as well as throughout the US, Puerto Rico, and Canada. We have customers in a variety of different sectors, from retail stores to grocery to restaurants, commercial office space, primarily here in the Northeast, large in the education sector, multifamily residential real estate world, and medical and wellness centers, as well as not-for-profits and religious institutions. As Diana alluded to, we do self-perform here in the Northeast. And we leverage a vendor network of roughly about 600 subcontractors or suppliers throughout the US, Canada, and Puerto Rico. We also carry very specialized insurance, which our next guest helps us with every year. And proud to say that we have no exclusions in our insurance policies for any of the work that we do throughout the US, Canada, and Puerto Rico. With that being said, I'll go ahead and turn it over to Craig Barnett from MSG to introduce himself.
Blake, thank you for the introduction and the opportunity to be here. Diana, thank you to you and your team at Fexa. I'm Craig Barnett. I'm a principal with MSG Risk Management. We are not insurance brokers. We don't sell insurance, but rather work with clients as a policyholder advocate, helping them with manage the ever-evolving world of risk and ensuring that their coverage, as well as those of contractors, service providers, et cetera, is up to a level and standard that will protect them in the event of a serious loss.
Awesome. Thank you, Craig. One shout out I forgot is to my mother, because I invited her on today's call. So I hope she was able to make it. Mom, if you're here, love you. Thanks for joining. So we have a few topics that we want to talk about. Again, there's the insurance and risk management spectrum is so wide. So we really tried, when we were putting our heads together, to kind of come up with some topics that directly relate to, our multi-site FMs, to our suppliers, all the way down to our owner operator, suppliers, that really affects everybody kind of along that cycle. So again, we have several topics we're going to touch on. One thing I do want to mention, for everybody to kind of keep in mind, and certainly for those suppliers out there, safety facility services, we're not just a supplier, but when we subcontract work downstream to our vendor network, we're also the client. And so, as the supplier or middleman, we always want to have our end customer's best interest at hand, but we most certainly want to make sure that we're taking care of ourselves and also looking out for the best interest of our end user supplier who's performing the work. So to kick things off today and turn things over to Craig, I'd like you to share a bit about contractual risk transfer, Craig. What is contractual risk transfer? Why is it important? And if you're able to, is there a cost associated with it, and what is that cost?
Great. Thank you for the opportunity again to be here. So if you're going to talk about contractual risk transfer, the first thing you really need to do is understand and talk about risk and define it in its simplest terms. And that is, risk is a situation involving an exposure to danger. It's a possible event that could cause harm or loss. So risk management is the process of identifying, assessing, and minimizing the impact of risk. There are a multitude of ways to manage risk, avoid, retain it. You can spread it out, you can prevent or try and reduce it, or you can transfer it. And today we are here and focused on, again, as Blake mentioned, it's a very broad topic. We could talk for days, weeks on it, put a lot of people to sleep, but we're going to focus on the part that's the most interesting to the audience, which would be the transfer of risk, and specific to the use of contractual risk transfer, because it is the cheapest in that it has typically zero cost associated with it, and specific to bringing on a service provider or a contractor onto a property. And examples of risk would be, or exposure to danger is bringing on a contractor, like safety. Are they cleaning windows? Do you have someone on your property that is changing a light bulb? Is there someone on property that is cleaning? So anytime a third party enters onto your property or your facility, there is an increase in risk, that increase in the possibility of danger. And when you look at that, you say, how can I manage that risk effectively? Well, one method of risk transfer that everybody's familiar with is we buy insurance for ourselves. But how can I, in addition to that, better manage my risk as a facility owner, manager, operator? That is to involve contractual risk transfer. And that really is, it's a mechanism through which liability for risk or liability for exposure to danger is allocated / transferred at the beginning of the relationship to the party that has the most control over that risk and is therefore in the best position to manage and control that risk. If I'm a facilities manager and I hire safety facility or whomever I might to clean windows or come in and change a light bulb or come in and do whatever services that they're going to do on my property, they're the professional. They are the ones who have an understanding of their operations. They are the ones that know where the pitfalls are, or should know where the pitfalls are, that could bring a potential for loss or damage or injury. So contractual risk transfer is that mechanism of saying in writing in the advance of a relationship, dictating to the party that has that most control over the risk and position to manage it, how we're going to transfer and push that downstream. So the first step in contractual risk transfer, it exists between two or more business parties, is to make sure that you have a written, signed, and binding contract. These contracts will spell out the terms, commitments, expectations, and legal requirements of a specific relationship. In these contracts, you have the opportunity to define and allocate the risks arising out of that relationship. And Diana, if you can jump to the next screen, if you would be so kind. There are multiple facets or aspects and clauses that businesses use contractually that will allocate risk. They include, if you can jump certainly to the next one, that would be great as well. Indemnification or an indemnity provision, duty to defend, hold harmless, also known as a waiver of subrogation. And then other important related risk transfer topics include certificates of insurance and additional insured status. I think Blake, if you
Yeah, so thank you, Craig. So one of the questions I had, as it relates to that, a lot of times we get set up with, a retailer, multi-site FM, they're eager to do business with us and vice versa. And they'll come to us and say, hey, I need a COI and a W-9 and fill out this banking form so that we can get you paid and, go get the job done. Is that putting them at risk by not having a contract in place with us, and or putting us as the provider at risk by not having a contract?
Less concerned about the downstream party in those scenarios and what their risk might be, but the answer is probably not as much, because assuming that they have the appropriate insurance coverage in place, their risk is their risk. The contract is always going to be the foundation, the initial foundation of risk transfer, and the first thing involved whenever any service provider is asked to come onto our property to perform a service for us. Because insurance coverage will always follow the written terms of the contract. And when you look at, some of these terms might be unfamiliar to some folks, they might be very familiar to some folks. And when you look at an indemnification, what is a hold harmless indemnification? What are those things? So first off, an indemnification is an undertaking by one party, called the indemnifying party, to compensate the other party for certain costs and expenses stemming from third-party claims.
Got it.
So what does that mean in non-insurance speak and language? If I am a facilities owner or manager and you come onto my property and you're going to do something that will damage my property or another third party that is on the property. Say, for example, a salesperson that's visiting or looking at samples in a warehouse, and you're working on a ladder and drop a tool, a bucket, or the ladder itself onto an invited or even an uninvited guest onto the property. There is damage, there is risk there is loss. We need an indemnification provision in a contract before you step foot onto the property that says anything that I do that causes a third-party claim to you, we're going to compensate you for. And in that example, the service provider, aka vendor or contractor, is agreeing to indemnify, again, compensate the facility owner and or manager for any actions that they do or omissions of actions that they perform that result in a claim from a third party.
Got it. Thank you so much.
Sure.
Another hot topic, and I know it affects everybody here, and I just alluded to it, certificates of insurance. So, we see them all the time. We're asked to provide them all the time. Anytime we onboard a new supplier or vendor or subcontractor, we require that they provide us with certificates of insurance. What can be done to ensure that COIs are being properly vetted by both, the suppliers or middlemen in this scenario, a company like Safety who may subcontract work downstream, and what can also be done to, vet it from the customer side, as the end user, or purchaser of that service? And is it ever necessary to not just receive like a COI, but to also, request policy documents from a proposed supplier, to validate any of the coverages that are listed on a COI? Would that be something that would be necessary?
Great group of questions, and the answer is yes to that last part, and I'll certainly circle back at the end of my next few minutes. So you talk about insurance, and there's a thought process that insurance, that a vendor, supplier, contractor, service provider has insurance, that's the end all be all. And unfortunately, that isn't the case. So you asked the question about contracts. Is it okay if someone shows up, they have insurance, they told me they have insurance, they give me a certificate of insurance, I tuck it away in the file, I'm covered? The answer is no, you're not covered. They may or may not be covered, but we don't know the answer yet. So when you talk about risk transfer, we're talking right now about contractual risk transfer. Insurance is the other most common method of risk transfer. An entity pays a third party, the insurance company, to transfer its risk for future unknown losses for upfront known loss, which is the premium. I'm going to pay you X dollars a year, and you're going to protect me for $1 million, $5 million, whatever our limits are, of potential claims down the road. So insurance is a method to back up the contractual risk transfer. So we talked about indemnification. We talk about waiver of subrogation. Waiver of subrogation is an important provision that we would like to see on a certificate of insurance. But again, back to the contracts, having an executed and written contract that establishes the indemnification agreement, establishes a waiver of subrogation, and that's a contractual provision whereby an insured waives the right of their insurance carrier to seek compensation for negligence from a third party. So let's use the example of the contractor that is on a ladder at one of the facilities. And they're on top of the ladder, they drop a tool, a bucket, whatever it might be, on a guest, and that third party is injured. They sue the facility owner, and they sue the contractor performing the services. It's extremely important that the contract exists in place between the facility owner and manager and that service provider, and that it has some very key provisions in it, including additional insured status. So if we can jump back to, I'm sorry, Diana, you're right there. Having additional insured status on the certificate of insurance is usually only triggered when there is a contract in place with the two parties. So if you receive a certificate of insurance and it lists you as an additional insured, or the service provider or facilities manager, the upstream party, as an additional insured, there is always language in the policy that says if there is a written contract. So triggering of additional insured status is only accomplished in most scenarios when there is a written agreement establishing that. So when you talk about reviewing a certificate of insurance and saying, is that sufficient? Number one, the contract has to be in place, establishing indemnification, hold harmless, waiver of subrogation, establishing the insurance limits, establishing, as we just discussed, that the upstream party is an additional insured. And for the audience that may or may not be familiar with what additional insured status is, that is where a downstream party agrees to grant the upstream party access to their insurance policy to defend a lawsuit against the upstream party that stems from the actions of the downstream party. So again, back to the example of the service provider on a ladder. If the third party were to get injured, sue the facility owner, sue the service provider, the facility owner doesn't want that responsibility, nor their insurance company's responsibility to defend and indemnify that that third party for that claim. They want to push it downstream to the responsible party. Back to when we talked about contractual risk transfer, we're pushing that responsibility to the party that is most responsible and has the best ability to control that risk. In this case, the facility, the service provider at the facility who's responsible for their own actions. If we can push that responsibility downstream via the contract, which we've done, then the downstream party, the service provider's insurance policy, would provide defense for the lawsuit, not just for themselves, but to the upstream party, the facility owner and manager. And that's really the goal of contractual risk transfer, is to insulate the upstream party from claims and defense costs associated with the work that the downstream party does. You also asked then about reviewing the certificates of insurance, and maybe if we can jump to the next slide, that would be great, Diana. This is a sample certificate of insurance. Not enough time to go through it at all on our brief time here together today, but this is an example that we can certainly share with the attendees after the fact. But a certificate of insurance has a lot of disclaimers on it. It's a synopsis of, if anyone's ever seen an insurance policy, whether it be your own personal insurance policy or your business insurance policy, you know it's very, very thick. A lot of words there. All of those words have meaning. It's impossible to condense all of the words and meanings in an insurance policy into a 1 or 2 page certificate of insurance. So while there are some key things that an insurance certificate will tell us, it is not issued by the insurance company. It's issued by the insurance broker. It may be inaccurate, and it may tell us some things that we need to know. It may tell us some things that are incorrect, and more than likely, it's going to tell us some things that we do not know. And I think, Blake, you've seen the example of a situation where you're trying to hire a subcontractor for a snow removal operation at a distant facility, and one of your clients just recently acquired, and we don't have a truck in that area, and you look to subcontract that snowplow removal, and you get a certificate of insurance, and something seems off about it, and we take a look at it, and what do you see? First exclusion on the policy.
They don't have coverage for snow removal or plowing.
Exclusion, literally right there on the policy. Didn't exist on the certificate of insurance. Same thing with a demolition contractor or a heights exclusion or residential work exclusion. Insurance policies are very, very good at managing their own risk on behalf of the insurance company. And that is excluding a lot of the things that you would most look for it to be familiar with. New York is an example. There are some very specific laws in New York. The scaffold law, aka New York labor law, A lot of insurance policies like to exclude cover for that via third-party action over exclusions. Not very well noted on the certificate of insurance, even though New York has a special addendum that tries to ask all of those questions. So the last part of your kickback to me was, is it ever enough to just review the certificate of insurance? Realistically, depending upon the volume of business you have, the number of parties that you're subcontracting to and outsourcing to, it's a Herculean to ask for and review every single policy of every service provider that steps foot onto your property. And if you're so the answer is yes, you should do it. Is it done by everyone out there? The answer is no. In an ideal world, it would be. But if you are at least getting an executed contract with all of the provisions we talked about and fully transferring your risk via contract downstream to the third party, indemnification, hold harmless, waiver of subrogation, requiring insurance, then obtaining a certificate of insurance, using this sample and others with your insurance professionals and your attorneys to check the box to make sure that you're checking that at least the information in the certificate of insurance is compliant with your contract, you're ahead of the game, much more so than most. The next and best appropriate step is to then confirm that the information provided in that agreement and in that certificate of insurance is backed by an insurance policy that doesn't have a specific exclusion. But again, that's a task that's a little bit larger for some companies.
Bit tedious. And I know many of the suppliers out there, and even in many of the multi-sites, do have like vendor management departments and things of that nature.
There's multiple third-party software companies. Yardi
Correct.
has Vendor Cafe, MyCOI, and a bunch of other ones that try to streamline that process a little bit, and they force them to put in some of the some of the actual exclusions and language of the policy.
Awesome. One thing you mentioned talking about the certificates, and we definitely wanted to keep this call kind of very global, where it touches anyone anywhere in the U.S. for certain. But being that we're a New York-based company, and being that I know so many of our guests today either are based in New York, do business in New York, manage facilities in New York, that third-party action over. Can you give us maybe a 3-minute rundown of
Sure.
what that third-party action over is in New York specifically?
Sure. So New York and Cook County in Illinois are two areas that have an antiquated law related to injury of employees. If I have an employee that works for company ABC Janitorial, and ABC Janitorial is at a real estate, any building, real estate owner, facility owner, building and performing services, if they get injured, their sole recourse against their employer is worker compensation coverage. They're going to get their lost wages, they're going to get their medical benefits paid, they're going to look towards their employer's worker compensation policy for pain and suffering if there's some sort of negligence on behalf of the employer. But worker compensation is that employee's sole remedy against their employer. The general liability policy has an exclusion for claims by employees against it because it doesn't want to become another worker compensation policy. However, an unamended general liability policy has an exception to that exclusion. The exception to that exclusion says we won't cover claims for employees of yours unless you agree to, in a third-party indemnification agreement, have indemnification for losses for your employees. So what does that mean? The building owner doesn't want a lawsuit for the employees of its downstream parties. Look to your subcontractor employees' worker compensation policy, and that's it. But in New York, what that employee can do is say, fine, I'm going to collect my worker compensation benefits from my employer, and now I'm going to sue the building owner. And it's strict liability, meaning that you do not have to prove negligence on behalf of the owner. That individual who fell off the ladder, the floor's flat, the building's well lit, nothing is wet. There is no reason why that individual should not have fallen off the ladder other than they were clumsy and they didn't follow their own ladder procedures still can and will sue the building owner and probably receive a fairly significant claim settlement. So what the building owner does not want is that claim to hit their general liability policy. So circling back to the beginning about contractual risk transfer and that indemnification agreement, I, as the building owner, am aware of this. I know this is a possibility. I don't want it to happen. So I push that risk downstream to ABC Janitorial. And what happens is if ABC Janitorial has that standard general liability policy that has the exception for injured employees covered from a third-party agreement, their insurance policy will defend me as the owner. ABC's janitorial policy will accept me as an additional insured, me being the property owner and facility owner, and they will defend me in the lawsuit. I did nothing wrong other than I owned a building and I hired a janitorial company. I've now pushed my risk downstream. My policy does not respond. The service provider's policy ultimately responds. But the insurance world has gotten smart, and they have said, we don't want, as the service provider, to also become a worker compensation policy. So we're going to add an exclusion, and there's probably 15 to 20 different ways to exclude cover for that. And it isn't always as overt as action over exclusion. I see it all the time. It's very clearly marked. Sometimes it's done via some very subtle ways that you can exclude that cover. But if it is excluded, what happens now is the building owner holds up their certificate of insurance and their agreement, their contractual risk transfer, and says, wow, this is exactly what I was afraid of. Your employee got hurt on our property. They're suing me. Thank God I've got this great contractual risk transfer. Here's your certificate of insurance. Please take this and send it to your insurance company. And they take it and they send it to their insurance company, and both ABC Janitorial and the building owner get a nice letter from the insurance company that says, sorry, we have an action over exclusion on your policy, not going to cover the loss. So now the ABC Janitorial is in breach of contract with the upstream party, the building owner. They're going to get fired. And the upstream party ultimately now has a loss that's hitting their insurance policy that they don't want to have on their program. So it's a big, big issue in New York and again in Cook County, Illinois.
Awesome. Thank you for that, Craig. Diana, do we have time for one more kind of topic with Craig?
Yeah, if it's not too terribly long, we want to wrap it up here in about 7 or 8 minutes.
Perfect. Yeah, this one, this one, it really affects everybody as well, just like all the other topics here. But Craig, sole proprietors, auto coverage, this whole, hey, I'm an owner operator, I'm a small company, I don't carry workers' comp because it's just me and, my son doing the work, or it's my wife and I that owner operate the business. So we don't have commercial auto and or don't carry workers' comp because it's just the two of us. Is that a problem?
Great question. The answer is yes and maybe, and more than likely. So each state with respect to worker compensation is governed a little differently. That is controlled at the state level in the Department of Insurance. And whether you are a sole proprietor, whether you are a corporation with only one executive officer and the executive officer is performing work, will dictate whether you do or don't have to buy worker compensation coverage. But ultimately, at the end, and whether you can exclude to include yourself on the policy. So you can buy what's called a ghost worker compensation policy if you're a corporation and you're the executive officer and you say, I don't wish to cover myself, but I don't have any employees. And you hand that to a building owner and say, look, I don't have any employees. I'm a sole proprietor. I'm not electing myself. Great. Well, what happens when that individual is gravely injured? They're going to try and find cover somewhere. The courts will determine who is responsible. And if that sole proprietor doesn't have the financial wherewithal, more than likely they won't, to give themselves care for the rest of their lives, the state's going to find a way to make your insurance company pay. So it's always important to make sure worker compensation exists. And if you have an executive officer or a sole proprietor and they're excluding themselves under coverage, be very, very careful of that. It's extremely important to look into those things. Commercial auto, they're going to say, I don't use my business commercially, but if they're traveling to your facility, they are using their business, their auto in business, and states are varied again about what's the course of employment. If you travel from site to site, are you in the course of employment at the time you get there? Or are you in the course of employment from the time you leave your home and are on the way to a new job site? So will workers' compensation trigger and will commercial auto trigger if you're on the way to a job site and have an accident before you even started for the day? So all of those things are great questions. Again, limited on time and individual state nuances, but those are questions posed for your individual insurance professional. And one of the things that I often see is or hear, if we have a vendor that we really need to use, they're not compliant with our insurance requirements, they're unwilling to sign an agreement, what do we do? Risk management's job isn't here to stifle business. It's not here to tell the business owners they can or can't do something, again, unless there's an exclusion in its business in the policy, but rather to educate the business on the risk and let the business owners make an educated decision on whether they find that acceptable. There's going to be situations where the ideal vendor does not check all the boxes. At least you'd like them to sign the contractual risk transfer and the agreement and push that downstream, even if there isn't the appropriate insurance backstop in place. But again, business owners will make that decision with our assistance.
Awesome. Thank you, Craig.
Blake,
Diana.
I'd like to get to at least one or two questions that have come in that you might deem appropriate to ask. Craig, has anything come in that you feel is good to put to Craig in the few minutes that we have left?
Yeah, I saw one here that I wanted to start with, and
Okay.
Craig kind of touched on this, but it's around kind of small value jobs. So if the job I'm
Yeah.
subcontracting is a small value, let's say under $1,000, do I still need them to sign an agreement and go through the whole insurance process and contractual process?
Awesome question. Whoever sent that in, thank you. Love it. The size of the job does not dictate the size of the judgment against you. So a $1,000 job can create a $10 million liability. In New York, hanging a window treatment inside an office, someone gets onto a ladder to hang a set of blinds. That might be a $500 job. That individual falls off that ladder, and you're looking at a multi-million-dollar claim. So the size of the job does not dictate the risk. Certain clients will look at hazard tiers, tier 1, tier 2, tier 3, to help really take a look at what work is being performed versus the size of the job and make an assessment from there.
Perfect. I have a couple more that caught my eye here. Who can we reach out to help craft contracts around risk management and all of today's topics?
So the individual's insurance professionals and their legal team will certainly assist in that. Often I am helping attorneys craft a very specific downstream party risk transfer relative to indemnification, insurance requirements, because they all dovetail nicely. I'm not an attorney, but I, again, do work with them to assist. So you'd reach out to your insurance professionals, your legal team. Anyone has a specific question that I can assist with, I'm happy to try and lend some insight if I can.
One that I just saw is a ghost policy for workers' comp, a workaround for compliance with regards to workers' comp.
It's a workaround that, depending upon state, the multitude of factors, doesn't accomplish the workaround for the upstream party. It is the check the box of, I have a worker compensation policy, so I am compliant with your contract. But if you are the sole proprietor or you are the executive officer and you've excluded coverage for yourself, the reason it's called ghost policy is because it's not providing any coverage for anyone. It's there simply to check the box of compliance of, I have a worker compensation policy. And that is where that creates the potential problem for the upstream party, in that when there is a large claim, the court system and the worker compensation system will find a way to bring that claim back to the company that they were performing the work for, which is exactly what you're trying to avoid. You have insurance, I have insurance, you go to yours for worker compensation coverage, don't look to me. The ghost policy is exactly that, ghost coverage. It's non-existent.
Thank you. And then lastly, what if the subcontractor's coverage limits don't align with our corporate policies and/or written contract? Can exceptions be made? Does this open us up to liability?
Another great question. The answer is that is a business decision. So unless there is a requirement in your company's insurance policy, and there could be, if you routinely engage in the use of subcontractors, service providers, or vendors, your insurance company may know that, and they may put in some sort of a clause in your general liability insurance policy that says you're covered for all these things, and here's your limits, and here's your regular exclusions, but we're adding this additional provision that says if you hire a service provider, you must execute a written agreement. You must require that they provide limits for these coverages, $1 million for general liability, $1 million, blah, 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 and go on, and not have any exclusions for action over, labor law, whatever you might want to call it. And if you don't have that subcontractor or service provider in compliance with that, your policy has no cover. So in the absence of that provision in your own policy, it then becomes a business decision of the upstream party to make concessions on what they do and don't find acceptable from a limits perspective and from a straight up coverage perspective. Back to the auto policy. Look, I'm just showing up. It's a state where driving to a job site doesn't necessarily constitute in the course of employment. I show up, I perform my work, and I leave. I don't have commercial auto. In that particular case, business management has a discussion with risk management, talk through it and say, based upon the job, the cost, the profitability, where it's located, how important this client is, how timely the need is, how many other vendors are out there that might be compliant, we're going to make a decision to knowingly allow this vendor who is not compliant to perform work for us. And again, that's a discussion.
Right. Thank you for that. Diana, there was like one or two other questions, but most of it was covered, kind of over the topics
Right.
here. So I think we're good on our end, unless you've seen anything else come in. And Craig, I don't know if there's anything else you wanted to share in closing, but thank you so much again
My pleasure.
for
If
dropping some
anything,
knowledge on us today.
Any takeaways? Contracts, right? Make sure that the indemnification risk transfer is all in place. At least get a certificate of insurance that's reviewed, and if you can, always review the policy.
Awesome.
Awesome.
Thank you so much.
Awesome wrap up. Thank you so much, Craig.
It was our pleasure. Hope everyone found it useful. I know everyone loves listening to people talk about insurance, but I tried to make it as relevant to the audience as possible. Any additional questions, happy to help.
Right, absolutely. Well, yeah, enough people registered that convinces me this is a very salient topic for many people, and it might not be as sexy as some other topics, but it's something that business owners face every single day. And this is important for smooth working relationships, and so that there are really no misunderstandings on the front end. And that's why contracts are important. So really appreciate you being here in your area of expertise. When we do send out the information and the recording, we'll send out contact information too. So if anybody wants to follow up and has additional questions, they'll be able to do so. So to that end, I want to thank everyone for coming to our show today and for the engagement. It's been great. I was watching numbers and most people stayed on with us for the entire show. So I really appreciate that. As mentioned, we will be emailing everyone a link to the recording of the show and to the presentation and to the ability to follow up with additional questions with both Blake and Craig. This particular recording and all Fexa Network shows will be available on the Fexa website and on our Fexa YouTube channel. and our resource library that's available 24/7 for on-demand viewing and downloading. Be on the lookout for future invitations to future shows. We will be having one next week as well, so be on the lookout for an invitation to that one. Thank you, everyone, and I wish everyone a great day.
Have a
Take
great day,
care.
Thank you,
everyone.
Diana.
Thank you,
Thanks,
Liz.
Craig.
My
Great
pleasure,
job,
sir.
guys. Take care, everyone. Thank you for joining.